So we're here in Washington outside of Eastern Market with Chris Soghoian. Wanted to talk a bit about the Electronic Communications Privacy Act reform hearing this morning at the Senate Judiciary Committee. Hi, Chris.
Hey there.
So what happened this morning? What did they talk about?
So this is the first time that the Senate has had a hearing on the issue. The House has already had two. This is something that sort of first started in March of this year, and it's taken the Senate a little bit of time to get around to holding a hearing. Now, this is the first time that justice has ever shown up. So there have been two previous hearings where there have been academics, companies, and other interested parties, public interest groups talking about the issue, but justice has never showed their face. Today, first time justice showed up, they sent definitely a big shot, but what they didn't have was any sort of position on these issues, and so they made a lot of vague statements. Concerns about some issues, their desire to maintain metadata access, which is non-content information associated with communications, and a little bit of scaremongering about cyber warfare and cyber hacking. But they really got nailed at the end of the hearing by Senator Leahy, because still they have no position on any of these issues. And the feeling on Leahy's part was essentially that if they don't hurry up and get a position on something soon, that they're not going to be part of the process. But so we had justice, we had commerce. Commerce didn't really say too much. They're supposed to be there to represent the business, the interests of American businesses, although they seem more interested in representing the administration and the justice position. Then you had Microsoft, CDT, and then a former Bush administration attorney who seemed to also want to hype the cyber war angle. The main take home for me was that, so the first thing is that only 4 senators showed up, which wasn't terribly great, but the senators did ask interesting questions. The senators also seemed to be really focused on cyber warfare, which again is interesting because this wasn't the focus of the hearing and isn't the focus of the ECPA reform effort, so it seemed like someone at Justice had briefed the senators and scared them into these issues, and so they, two in particular, including Senator Whitehouse, seem real concerned about the need to put government devices on private networks to make sure that viruses weren't spreading around. That again didn't address the main issues in this ECPA reform effort, which are the desire to protect location information and to protect email and other cloud stored documents. Mr. Baker, who was from Justice, made an interesting point, which is that when individuals and companies are considering whether they want to put their data in the cloud, in addition to the usual concerns of reliability and security, government access may be an issue, or should be an issue that they need to consider. And I think the perspective of the companies, and definitely the public interest groups, is that people shouldn't have to consider government access as one of the issues when they embrace cloud computing. It should be about cost, about efficiency, about green energy, about reliability, about backups, but government access shouldn't be the issue.
And did that come through this morning? I mean, because the crucial issue around updating this law, we're talking about something that was enacted in 1986,
right.
Is the difference between the protections between electronic communications that are stored on your desktop between those that go out into the cloud, one of the providers, which really are not treated the same way. And even communications, as Brad Smith and Microsoft pointed out, are treated differently even if one is slightly older than one from another.
Right. So there's a 180-day distinction. So Brad Smith made a really good point there, which is that an email that you open and decide to keep because it's important receives less protection under the law than a spam message that you delete or move to your spam folder as unread. And that seems totally counterintuitive. We keep important emails for years now because they're from a lover or a family member or a business partner, and it's just not. It doesn't mesh with our expectations and our use of technology that after 180 days, or the moment we click the read button, even if we're just skimming the message on a mobile device for later reading at our computer, that we instantly lose those protections and go from a probable cause warrant down to a subpoena that is basically just a letter on official letterhead. So that was an issue that the providers, or at least Microsoft, really pushed for. Tomorrow there's going to be a hearing in the House. It's not going to be big shots, but it will be the people at the firms who know the issues and know where the bodies are buried. So that's going to be really interesting. I'm expecting some fireworks there, both a combination of the companies themselves, law professors, and Ed Felton from Princeton, who really knows these issues inside out. But we're not expecting to see anything happen before the end of the year. There's going to be a lame duck session, and it doesn't look like there's going to be any movement. But it's been 24 years since we had this law updated, 24 years, and it's about time they fixed it.
Now, what are some of the other reasons that this coalition of tech companies and advocates have started Digital Due Process and digitaldueprocess.org? What are the distinctions between where the law lays down privacy protections and the ways that technology has evolved since then?
Right. So they have 4 principles. There are a few sort of main categories of issues where the law just has totally not kept up. And you don't see the words email or location appear in the law, and so courts have had to sort of read into it. And so we have this really weird area where if you want cell tower data that's historical, you use one kind of court order. If you want prospective, which is data in the future, you get another kind of order. If you get cell tower data, you get a weak order. If you want GPS data, you get a more restrictive order. Particularly with cell towers, where in urban areas you have very, very small areas around each tower, or if you have a microcell in your house, the tower is essentially your living room. That's the area of coverage, and so tower data is also increasingly becoming more and more accurate. So the main areas we have are location data, the complete lack of sense of this 180-day distinction with email and whether search records are considered content as well, and then social networking information. There's just a complete lack of clarity with regard to whether social network information should be protected. Justice has refused to admit what it thinks the law is in this space, but certainly the social networking providers want some clarity and also want protection for their customers. And I think the membership of the Digital Due Process Coalition is really interesting, right? So you have companies, you have public interest groups like EFF and the ACLU and Center for Democracy and Technology, but then you have both liberal and conservative groups. So you have Americans for Tax Reform, you have FreedomWorks, you have the Progress and Freedom Foundation. So groups that traditionally would not be part of this are, and it really is everyone but Justice that has come to the table. And what seems to be the case is that Justice just isn't really negotiating, and isn't willing to talk about what they want, isn't willing to talk about what they're currently doing, and is really they're really just dragging their feet on this issue. But I think what this coalition has done is they've figured out, look, if we get everyone else to agree, then maybe we have a chance of pushing forward. Because in years past, the public interest groups were fighting with the companies, and there were political divisions over this information. And so what they've done is they've been very savvy. They've taken national security off the table. So this is just about law enforcement access. This isn't about FISA. This isn't about national security letters or the Patriot Act. This is just about law enforcement. They are leaving the issue of emergency access off the table. So providers are still free to voluntarily provide information in cases of life or death. And what they've done is they've just focused on a couple key points and gotten everyone to agree to it. And I think that creates a very compelling situation where it's difficult for the government to say that these guys are out in left field, or they're activists, or they're extremists, because you have these very respectable companies. I mean, you effectively have EFF and AT&T at the same table, and these are organizations that were suing each other over the NSA's warrantless wiretapping, and these guys agree. So I think it just creates a really, really good a good unified front.
So what's at stake if this doesn't get updated? Obviously, the prospects by the end of this session are pretty low, but there may be a legislative framework or basis for legislation going forward to the next Congress.
Right. So, the issue is that companies and consumers want to shift data to the cloud, and right now, you as an individual or you as a company have far less privacy rights for your data when you put it in the cloud, and in particular, foreign companies are extremely unwilling to give their information to American cloud providers. And if we don't sort out the law and Congress doesn't get around to updating ECPA, I strongly feel that this area of the market and these companies are not going to see the growth that they're expecting. And this is actually this is a jobs issue, particularly because the data centers are being built in what were formerly sort of industrial rural states, with access to grid and cheap power. So we're going to see less data centers being built. We're going to see less infrastructure, less smart grid money going to supply these data centers, and we're going to have more data breaches and other issues as companies keep the data themselves and try and do things in-house, right? So whether you think that giving your data to Google is a good idea or a bad idea because of their monetization techniques, one thing is clear is that Google has a team of security engineers working 24 hours a day to keep their data secure, and most of the time they do a good job with that. And most companies don't have a team 24/7 doing that, and so by telling companies that by giving companies a reason to not embrace cloud computing, and by giving individuals a reason to not embrace cloud computing, we're effectively leaving data at risk by forcing individuals to be their own chief security officers and forcing companies to do things in-house. So I think there are ramifications here. I think particularly with regard to location data, since there's just such a lack of clarity, and because the government is getting this information on such a massive scale, we need an update to the law.
So you've written a couple times about some of the ways that the government is getting location data or other information, for instance, from the telecommunications providers.
Right, so last October I went to a conference, a closed-door surveillance conference, where government agencies, telecommunications companies, and the companies that make surveillance gear get together to sort of talk about what's hot in their field. The conference will be actually, again, this October in DC. And I recorded an executive from Sprint talking about what they had done. Now, in the past, they provided instant real-time GPS lookups of their customers to law enforcement, but law enforcement had to call up Sprint and initiate the query, and so a Sprint employee would have to type a command on a keyboard, and then they would look up the information, and that was time-consuming and expensive, and so what Sprint did is they made a special website where law enforcement could log in and access the information whenever they wanted to. And in 13 months since that website went live, they processed 8 million queries for government agencies. That was the first time we had any information about the scale, and that was just one carrier. We know that other carriers are providing location information. What we don't know is by what means, whether the providers are providing it through a website or whether they give the information when you call them up or send a fax. Certainly, the more automated it is, the easier it is to use, the cheaper it is, and the more frequently the law enforcement agencies will get it. But what we don't have are good stats. We know from information that Verizon submitted to Congress a few years ago that they, at least back in 2006, were getting 80,000 requests a year. 25,000 of those requests were emergency requests, which means there was no warrant, no court order, no subpoena. They just call up and say it's an emergency. And so there's every reason to believe that location is increasingly becoming a major component, a tool that's used, whether there's a murder, whether there's a car theft, whether there's a robbery, and what we don't know is just how often it happens and how much money the providers are making off of it too. And so Sprint isn't providing this for free. If Verizon is nickel and diming you on 411 calls, then they're definitely going to be nickel and diming the government on these location services. But because we have no clarity there, and because we're walking around effectively with a GPS tracking device at all times, this is certainly probably the most important issue in the ECPA reform effort.
So for someone who's walking into this and is not a tech policy wonk, who doesn't have the background that you do in terms of electronic privacy and research, which I gather you're continuing at Indiana University now that you've switched positions, what are the best resources to learn more about this and to protect yourself where possible against some of these intrusions?
So, there are great resources at the Electronic Frontier Foundation, the ACLU, Center for Democracy and Technology. They have white papers. They have some videos that you can watch. When it comes to protecting your data, there's actually very little you can do, right? So, if you use Google Docs or you use Gmail, there's nothing that you can do to stop the government coming with some form of order and compelling them to give your data over. What you can do, though, is you can pick providers that have better privacy policies and better privacy-enhancing technologies built to their products by default. So, as an example, I use a cloud-based backup service called SpiderOak. They encrypt my data. They store it in the cloud, but they use an encryption key that only I have. So they can never be put in a situation where they can disclose my data. Similarly, I use Firefox Sync, which is a tool that Mozilla has that lets me synchronize my cookies, bookmarks, and passwords across multiple computers. That data is stored in the cloud, but it's encrypted with a key that only I have. So Mozilla can never be put in a situation where they are forced to divulge my information. None of the big email providers currently offer encrypted storage. None of the online word processing or spreadsheet providers offer that. None of the photo sharing services offer that. And so my advice in that space is be really careful, because none of those providers can currently protect you against government access. When it comes to picking the phone company you use, you actually have a little bit of control, right? So Sprint assigns every customer a static IP address, and so as long as you're in the same geographical region, you have the same IP address at all times for your device. They know which customers they've given which IP addresses to, and they keep logs of that for 24 months. Sprint also logs every URL that you visit from your device that uses their proxy for 24 months. So Sprint knows everything you're doing, everywhere you are, and every web page you're going to from your handset. Verizon also keeps IP addresses of the sites you visit, and for 30 days, and I think they keep the IP addresses that you're assigned for a year. T-Mobile, on the other hand, doesn't log any they don't log any information on which sites you're going to, and more importantly, they have a small pool of IP addresses that they assign to every device, or to every sort of region, which means two different T-Mobile users will effectively have the same IP address in a city. And T-Mobile doesn't know who's using what at any period of time, which means that if T-Mobile receives a request after the fact, let's say a T-Mobile user posts something defamatory in a blog somewhere, or in the comments on a blog, and the person gets offended and goes to T-Mobile and says, this IP address was doing something really bad at this time, T-Mobile has no idea which customer was doing that. And so by picking the right phone company, you can actually go a long way to protecting your privacy. We don't know what AT&T's practices are, but of the three that we do know, Sprint, Verizon, and T-Mobile is by far the best on privacy. Unfortunately, they don't have the best network, but they do at least have the best privacy practices. So, in some areas, consumers can vote with their dollars and pick privacy-preserving companies, but at least when it comes to cloud-based email, cloud-based word processing, and other applications, all the providers currently are pretty bad.
Okay, well, thanks for the update, Chris, and I'll be looking forward to more of the hearings tomorrow. And for people interested in learning more about digital due process, again, that's digitaldueprocess.org to get more information about the Electronic Communications Privacy Act and proposed updates.
Thanks.